Start. Para. Before dealing with the rival contentions of the parties, it is necessary to record that during the course of the hearing, the learned counsel for the respondents tendered a fresh certified copy issued to the respondent by ALT. According to the respondents, an application was filed before the ALT on 1st March 2023 seeking certified copies of the 70(b) proceedings and 32(g) proceedings. According to the respondents, a fresh certified copy was issued on 9th March 2023 to support the submissions. An affidavit of respondent number 10 dated 3rd May 2024 is filed. Learned counsel for the petitioners submitted that after the petition was admitted, the records and proceedings of ALT and Tenancy Appeal Number 9 of 1992 and the record of MRT were in the custody of this court. He therefore submitted that there was no occasion for ALT to issue a fresh certified copy. Learned counsel for the petitioners thus submitted that such issuance of said certified copy at this stage supports the allegations of the petitioners that respondents, in collusion with the tenancy authority, have created, forged and fabricated orders. Learned counsel for the petitioners further submitted that a perusal of the certified copies produced by the respondents is at variance with the original document, which is part of the record. The application for certified copies and the two certified copies tendered by the learned advocate for the respondents on 2nd May 2024 were taken on record and were kept in the custody of the court Shirastedar. Para. In view of the peculiar facts and circumstances of the case, I am not inclined to examine the veracity of the said documents produced on 2nd May 2024 in these proceedings, but appropriate directions will be issued in the operative part of this judgment. With regard to the rival contentions of the parties on the claim of the tenancy rights seeking fixation of purchase price, it is necessary to record that the application filed by the respondents under section 70(b) was initially allowed on 28 November 1991. Admittedly, the said application was filed claiming tenancy rights through Ganpat. The claim of tenancy admittedly was only for 30 acres out of the entire land. The said declaration was set aside by the SDO on 13th January 1994, though there was an order of remand passed by the MRT on 4th April 1995. It is not in dispute that after remand necessary inquiry was made and the appeal was again allowed by the SDO on 27th May 1996 and the claim of declaration of tenancy by the respondents was set aside by the SDO. It is not in dispute that as of date the said order has attained finality, though it is sought to be contended by the respondents. The tenancy appeal number 55 of 1996 is filed by the respondents and is pending before the collector. There is no record indicating that such an appeal is actually filed and is pending. Thus, a perusal of the record indicates that the claim of tenancy rights of the respondents with regard to 30 acres of land stands dismissed. Para. Admittedly, in the proceedings under section 70(b), no document was produced in support of the tenancy rights. However, in the proceedings under section 32G, a lease document purportedly executed on 12th June 1950 by Vinayak, son of the original owner, was produced. Thus, in 32G proceedings, the tenants raised a different stand that he was a tenant with regard to the entire area, based on the claim of the respondents regarding that area. Learned member of the MRT has examined the claim and declared the respondents as tenants with respect to the entire area by completely ignoring the rejection of the tenancy rights of the respondents and the contrary stand taken by the respondent. The learned member of MRT has proceeded to grant a declaration of tenancy with respect to the entire area. Stop.